Good morning. Shall we get started with the slight delay of 10 minutes? Otherwise, we're just running late all day. Well, it's my pleasure to welcome you to the ACELG annual conference, so the Amsterdam Center for European Law and Governance. We have been holding these annual conferences since 2011, so we're very proud that we hold this every year as an event where we usually try to offer academic reflections, fundamental reflections, on issues that are part of the contemporary debate. And we have done so in the past on European economic governance during the crisis. We have done so last year on the EU and social justice. And this year, I think we could have hardly chosen a topic that is more hotly debated in Dutch politics, certainly, but in most of the member states and at the EU level. And that is the Energy Charter Treaty. We could have also hardly chosen a topic that interlinks more closely both with the European European constitutional law interest of our center, where many people work about questions of power shifts and questions of what is possible for the EU, what is possible for the member states, but also interlinks very closely with sustainability. So something that ACELG has become more and more involved in the past, I would say, 3 to maybe 4 years. And now as part of sustainable global economic law, also in connection with other centers in the faculty, where we really focus on how law shapes sustainability and what are the legal conditions for moving towards a more sustainable world. And the Energy Charter Treaty, of course, lies at the center of the energy transition in many ways. It's a sectorial investment agreement, so it's an agreement that focuses on one economic sector, namely the energy sector. So in that sense, it's fairly narrow. But on the other hand, it has many contracting parties. So with its 53 contracting parties, it is nonetheless the most litigated investment treaty in the world. So in many ways, it is also of high relevance for that reason. In addition, of course, it is extremely topical, and I will get to a moment why. At the moment, we are discussing it in such depth, not just because of its importance, but also because we are in a political process of having to take a decision. And the political process of having to take a decision will really happen in the coming weeks. So we had the situation, in principle, they were most clear since the Comstroy decision of the Court of Justice in 2001, that intra-EU arbitration, so arbitration from an investor from one EU member state against another EU member state, is illegal under EU law. Since then, in principle, because it's illegal under EU law, both the EU and the member states are on an obligation to do something about that, so to address that illegality under the Energy Charter Treaty. But already since 2019, the Commission had anyway a negotiation mandate to renegotiate the Energy Charter Treaty and to bring it in line with the Paris Agreement, the commitments to reduce emissions and reform, some say modernize, a treaty that was created in the 1990s and that is in many ways, in light of what we need to do in the energy sector, so the energy transition, completely outdated. And I think that is almost a generally accepted truth that the Energy Charter as it stands now is completely outdated. And with that mandate, so they have been negotiating, and since June 2022, we have a new text. So the text is agreed in principle, and the contracting parties of the Energy Charter Treaty will vote on that text on the 22nd of November. So in, what is today, the 4th, 18 days. So that is why currently in the European Union, the member states determine their position. So some member states have already clearly said that they will withdraw. And I mean, all this will come back in the talks that we hear today. I'm just sketching a bit the background, why this topic is so hot and so interesting. And I'd sketch it a bit for those who maybe in their daily working lives here are less engaged with the Energy Charter Treaty. So in the next 18 days, the European Union has to take a position, which in concretely means that the Commission has made a proposal on what should be the position of the European Union at the Energy Charter meeting, so the ministerial meeting of the Energy Charter Treaty on 22nd of November in Mongolia. And the question is now, will the Council accept that proposal or reject that proposal? And that's why it's all also in the press, why the national governments discuss it, why we had a letter from the Energy and Climate and Energy Energy and Climate Minister, or the other way around, in the Netherlands, determining the position of the Netherlands to withdraw, but still keeping open how the Netherlands will vote in the Council decision that will determine the EU's position. And this is, of course, very complex under the Energy Charter Treaty. As we will hear, it's a mixed agreement, so everyone is a member, the member states and the EU. So is it possible even for one or the other to withdraw with the other stay? And what are the consequences of that? That is one aspect that we're going to be discussing today. Another aspect we're going to be discussing in different panels is the sustainability question. So the question of how bad is the Energy Charter Treaty for sustainability? I think that is how you can reasonably pose the question. So as I said, it's the most litigated investment treaty in the world with 150 cases recorded. But that, mind you, doesn't mean that we only have 150 cases, since there's a high level of lack of transparency. So even the Secretariat of the Energy Charter Treaty says that, well, it encourages all contracting parties to report cases, but it doesn't mean that we know of all of them. We certainly don't know of those that were settled. So the number is, likely higher than 150 cases. That's what we can say. In addition, what we know, and that has also been discussed in different ways, and academics have written on it, and we will also have Kaila Tiamhara in the last panel who has written on this. There's the issue of regulatory chill. So the fear of investment treaties, the fear to have a claim against you when you change your policy. And when we say change your policy, then in the context of the energy transition, that means adopt climate laws, adopt laws, for example, in the Netherlands and Germany, to phase out coal. And I just want to give one example, because it's not my personal research, but one example where we can clearly see how important the claims under investment state dispute settlements are, and particularly under the Energy Charter Treaty in the context of energy, is in the contract, in the public law contract that Germany concluded with a number of energy providers when they phased out coal, and where they paid several billions of damages to the energy providers. And in the public law contract that they concluded with the energy providers, amongst others RWE, but also others, it said clearly that the compensation is also paid because they commit the energy providers to not bring ISDS claims. So there's a whole page in the contract saying that the contract ends their possibility to bring ISDS claims, or that is in any event the aim. And this was also the legal advice of the ministry at the time. So there we can see how it directly plays a role in the level of compensation, because it is, you get compensation for committing not to bring an ISDS claim. And I should maybe also add that the Commission looked into this as illegal state aid, because the compensation was so high. And why is the compensation so high? Maybe that's my final word of what we will be discussing in the context of sustainability, is because the Energy Charter Treaty offers compensation for future uncertain profits. And that's the big difference between the Energy Charter Treaty protection and protection that any one of us, any investor and anyone else, enjoys under domestic law. So under domestic law, under the ECHR, we all enjoy the protection of the right of property, but that is in the interpretation of both the Strasbourg court, but also the Luxembourg court, does not extend to uncertain future profits. So the compensation that you would be paid in case of expropriation would be significantly lower. And we will hear much more about these details. I just want to sketch a bit the scene for you to know where we are and what we're discussing. So at the moment in Europe, the main question is, well, you can either formulate it reform or exit, or if you want to be a bit more forward, you say that already there's an avalanche of member states saying that they will exit. The question is only when before or after reform. And of course, who else will join withdrawing, as we still don't know the position of a large number of member states. I want to end with two little footnotes, and the first is, last year we had the conference on the EU and social justice, and I think this is an aspect that in many ways does not figure very highly on the political agenda when we discuss the Energy Charter Treaty, namely the question of justice in that context. And in that context, what we should emphasize is that in October, the Secretary General Guy Lenz said that they want to expand the Energy Charter Treaty to 40 additional African countries. And the question is, of course, what is also the responsibility in terms of climate justice, in terms of North-South global justice of the member states that want to withdraw from the Energy Charter Treaty because they think that A, it's outdated in sustainability terms, but also because they're afraid, let us not underestimate that aspect, of having billions of claims worth billions of euros against them, to at the same time encourage this expansion to 40 countries that would probably not, or at least to a large degree, not be in the position to pay the damages that Germany paid the energy providers that I just talked about, because they simply wouldn't have the financial means to do so. So that is also something that is lingering in the background, and I think that has not figured very highly on the political agenda, but it is a question that we must ask ourselves in that context. Do we want the expansion of that treaty also to other countries? Is that politically the right position? Finally, I want to end on saying that this annual conference is organized, co-sponsored with the journal Europe and the World, a law review, and we are hoping ultimately to get from our speakers to publish some sort of an intervention in our open access journal that hopefully will contribute these academic insights to the debate also in the long run. Many thanks. And without much further ado, I think I hand the word over to Alessandra, who will take us much deeper into the content. And I was just sort of sketching the scene for you, particularly for those that follow the debate less. And Alessandra Arcuri from the University of Rotterdam will go with us, take it away, and tell us in particular about a recent case that I haven't mentioned because I didn't want to, pick in your presentation. But I think that will illustrate to us many of the problems that arise from the Energy Charter Treaty. Many thanks. Thank you.
If I'm sharing it correctly. Voila. Yes. So thanks a lot. Thanks a lot, Christina, for yes. You don't have to do that. Okay. Yeah. Can everybody hear me? Yeah, you do? Perfect. So thanks a lot for having invited me to share some thoughts on the Rockhopper case and also for organizing this topical conference. I think you already covered a number of very important issues, and I'm focusing on those issues that you mentioned, particularly sustainability, and in a sense also social justice. As you see, I have made a choice in the title on how to fuel the fossil fuels economy. So for me, fossil fuel is an important word. And what I want to do in the remaining 15 minutes is to show that Rockhopper is a paradigmatic case of how the ECT fuels the fossil fuel economy. And I will do this in 4 steps. First, I will say something about this type of economy and environmental crisis under which we are living now. Then I will say something about the role of fossil fuel companies in shaping the law, a law that enables such type of economy. And what are the drivers of change for climate action? It is democratic mobilization. And I will conclude by a synthesis of why I think the ETT erects legal barricades to change, and the Rockhopper is the perfect illustration. So let me start with this premise and to use the F word, which is highly unused given its importance. So the fossil fuel economy, the F economy. We always talk about climate change in this relation, and today I think this is the focus, and for the right reason this is the focus, but we shouldn't forget that the fossil fuel economy is a major driver of other type of environmental disaster, and I just outlined very synthetically. First, we have pollution from upstream extraction of local communities and environment. Consider that there is an estimate of 70,000 oil fields globally, so I'm only talking of one of the fossil fuels, and with impacts on 600 million people. What does it lead? Extraction of oil, contamination of water, both drink and surface, marine pollution, impact on wildlife and agriculture, soil pollution, high mortality and morbidity risk. Risk factors include oil spills, both major oil spills like the Deepwater Horizon that I will touch upon later, but also systemic oil spills. And we know of this type of spills in Nigeria and all the cases you read in the newspaper, and air pollution from flaring, something which is not often discussed. Now, you cannot see on the slide, the problem is that the evidence is fragmented if we want to think of the global impact, but there is an interesting studies from last year, which I am happy to share, and these effects are systemic and relevant. There is a second type of effects, that's from air pollution caused by burning the fossil fuels. So from a report of 2018, there is 8.7 million premature deaths annually. So it's about 1/5 of all deaths relate to burning of fossil fuels, driving cars, etc. The costs are 2.9 trillion for 2018. And then, of course, we all know that burning fossil fuels contributes to more than 75% of greenhouse gases emissions, which are major drivers for climate change. In that we don't talk about it, also ocean acidification, which is environmentally also quite a drama. So the energy charter treaty that we are talking about is also about the fossil fuel economy, not only climate change, although climate change is obviously a key of key importance. Second premise of my talk is the fossil fuel economy doesn't come naturally in this world. It has been fostered by lobbying efforts, systemic lobbying efforts of the fossil fuel industry, which is documented by a rich literature that is mushrooming these days because we have access to documents and how this industry has fostered a strategy of doubts, manufacturing doubts, as fostered denialism and delayed regulation. This leads to a law that enables the fossil fuel economy. So the law that we have today is not just a law, it's a law that is enabling. We are miserably failing in tackling climate change because of the laws we have. So we need change, and that's recognized everywhere. IPCC report, although I think in the introduction they omit the word fossil. And what are the main drivers of change? It is social mobilization, is horizontal democracy. We have in the Netherlands a lively climate litigation, as in other words, Youth for Climate. We also have a phenomenon of scientists resisting the harassment from the lobby of fossil fuel, which is also has been quite well documented, for instance, by Wendy Wagner on bending science. So with these two premises, let me go into the Rockhopper case with a very brief history. Probably is a case you all know, so I'll just go very briefly through it.
Don't necessarily assume that everyone knows the background.
All right, so I just want to say that I necessarily have to oversimplify because this is a very complicated case. So I will talk you through the main steps and then in the Q&A go further. But we could trace a potential beginning of this case, which is not the real beginning, but to 2005 for reason of simplicity, where a company, Med Oil Gas Italia, obtains a permit to explore, to see whether there is oil. This permit is obtained without consultation for the local people. In fact, in 2008, the story is people wake up in this very beautiful coast in Abruzzo, in the east of Italy, the Costa Teatina, also with a number of protected natural areas, and they see less than 7 kilometers off the coast this gigantic jack-up rig, really gigantic, to explore for oil. Apparently an oil of bad quality, but let's omit the details. In 2010, we had one of the biggest environmental catastrophe in the US, the Deepwater Horizon oil spills. Incidentally, this is something that is not found anywhere. The jackup rig is owned by the same owner, so the Italian jackup rig is by the same owner of the Deepwater Horizon oil, with the flag of the Marshall Island. So as a reaction, next to many mobilization of the local people, which I omit here, there is a law adopted to prohibit offshore drilling within 5 miles from the coast and 12 miles from the coastal protected areas. And we do have then a negative advice of the technical committee on the environmental impact assessment. So at this point, the Ministry of Environment should have denied the permit. For 2 years, the Ministry of Environment does not act. For 2 years. So this made possible that despite of this negative advice and this law prohibiting offshore drilling, in 2012 and in 2014, we have 2 law decrees that carve an exception for companies already asked for a permit. This is an exception. This case is all about an exception. Is this exception coming from somewhere? Here it is speculative because it's very hard to establish a causal relation between lobbying and effect. But for example, some parliamentarians have excavated and found letters. In Italy, we are famous for letters between politicians with letters, right? And there is a sweet letter between the CEO of Medoil at the time, Sergio Morandi, and the Minister of Environment, which incidentally later has been also convicted for corruption for another case, but it doesn't matter. In August 2014, with a certain background that I will further explicate in the next slide, Rockhopper buys Medoil. All right, so now on Brina, it's possible with this exception. But let's look at a little bit of a background. This territory is known from the 70s, from strong mobilization against the oil-driven economy. This is documented in books by anthropologists and historians. All companies, including any that try to establish oil refineries, have been kicked out of the territory. When, after in 2003, we have this positive environmental impact assessment, thanks to the exception, there is massive protest, and by massive, like 40,000 people in a small Italian town in Pescara, unseen before, not to mention the 2015, 60,000 people. There are conferences and meetings with scientists, intellectuals, observation to public consultation, submitted en masse to the environmental impact assessment, etc. The reasons for the movement No on Brina are variegated, but I want to mention that there are many scientists involved in the No on Brina. It's a transsectoral movement from the church to the extreme left, the right wing, all are against Brina, but the government. This is not a case about climate change. This has been said, and it's partly true and partly not. Because in 2014, we have a group of scientists submitting public letter, talking on public television, saying it's a short-sighted policy to open up new oil fields. We have to invest in renewables. Italy is a territory that can really flourish on renewables. So the Rockhopper case is also about the energy transition. Participation, there is also in the movement of science, and here there is a short parenthesis. I know I'm running out of time, but it's important. So I went to Abruzzo, I talked with some of the people in the movement, and there was something that really changed my way of looking at this, is that we asked to some of the scientists, but you are really good as a movement, not as the people in Basilicata, because we have a little Texas in Italy that is Basilicata. And then one of the main activists told us, no, we are really grateful, because the knowledge that we have about the environmental side effects, we want to call it like this, of extractivism, they come from the people in Basilicata, from the people in Sicily. So there is another little Texas in Italy. There is where we extract 80% of all hydrocarbons. And this type of knowledge is a knowledge that came to struggle. So we have a territory where the public institution didn't do the monitoring, didn't do the epidemiology. The first type of evidence came from what an anthropologist has called scientists of proximity. Scientists in the territory that went together with people also in the institutions which were harassed, took sample of water, the main reservoir of drinking water in Basilicata, and saw that it was contaminated. And then we have some epidemiological study. The cancer rate in this place is higher than the average cancer rate. So there is epidemiology, which, however, we have it despite the public institution. And there is a terrible effect on this, the cultural economic texture. Here is the social justice, and just a quote from someone from this territory in Basilicata. These are, by the way, the pictures of the beautiful Basilicata and one of the main refineries that I think they're not very beautiful, but I think one quote is revealing. One person say, until yesterday, for people of Lucania, the soil was an element of cultural and social identification. Today, they think that natural resources could be compromised, and this changes profoundly their identity. In their imaginary, nature has been transformed from a source of life to a death risk. All right, so final denial of the permit, fast forwarding. On the 6th of July, we have a new movement. There is a mobilization for referenda to abolish, let me put it simplistically, the main effect of these 2 degrees. And there is a request of the movement to Italian regions. On August 2015, there is a positive evaluation of the technical committee of the ministry. In September, we have a referendum supported unanimously by the Conference of the Presidents of the region and were requested by 10 regions. This is not very common to have referenda initiated in this way. It really shows a mass support of the referendum. Under this pressure, the government by Renzi reviews the exception, and in the 2016 stability law passed a rule by which offshore drilling from 5 to 12 miles from the coast is prohibited without exception. So here is the end of the Ombrina project and denial of the permit. And here is the beginning of the ECP case. On 14 April of 2017, Rockhopper lodged a complaint before an international arbitration tribunal. The case is not still pending, sorry, or maybe it is because there is a request of annulment. Plausible claim, I thought when I was writing this case, was breach of fair and equitable treatment, legitimate expectations. But on 24th August, we have the news that an award in favor of Rockhopper has been issued by the arbitration tribunal, with a compensation of 190 million plus interest of 250 approximately, versus an investment of 40 million. For an oil corporation, this is really a dream. That you invest, you do nothing, and you get such an amount. But what is interesting is that the main findings actually is expropriation. No consideration of fact. And here I am really speculative because the award is not public yet, and I am not among the elite that had the pleasure to read the award, and that's something else about social justice. Such a case, we have a reporter with a commentary, we have other in the arbitration elite community that may have seen the report, but we cannot. Anyway, from the leaked commentary on the report, we see expropriation, and My hunch is that, at this point it's really politically not tenable to say that that had legitimate expectations to such business. So they went to the expropriation. In 2022, Italy, so in October, just a couple of days ago, Italy filed a request for annulment. I think this will be very difficult. Here, my tentative conclusions, having not read the award, these are very tentative, but the first. ECT is a legal barricades against environmental policy because it does ossify a law that protects the fossil fuel economy. What do we see in this case? I think the first point is on which we probably may all agree, hyperbolic damages, as Christina was already mentioning. Even if you would agree on the point of law, I don't think any tribunal domestically would award such damage. But the point I'm more interested to explore is the hyperformalism, or should we call it fossil formalism? What we see from the leaked commentary is that they see that the company should have the right to property once there was this environmental assessment positive, because apparently there is a decree of 1994, which Italy says that is not enforced, but this we cannot really judge. But anyway, they say they should have had the right to property. So there was not permit, a property, technically speaking, was not there, but there was a right to property. And then they say the precautionary principle would not apply from August 2015. Now, under WTO, we have evolutionary interpretation of international law in light of treaties. Here, I would say we see an involutionary interpretation of law. Again, I have not read the award. But a last point, do we see that fossil law is a fossil fuel property? And now I go back, and I'm about to conclude, to the exceptions, because from what we see, one line of argumentation is that the exceptions were given because the companies say, otherwise we are going to sue you. And there is, there are newspaper articles at the time that make this type of argument. So in a sense, then the award actually is given on the basis of the exceptions, because the exceptions were, I mean, this is the law that we have. This is a positive impact assessment given because there were these exceptions. But if the exceptions were enacted because of the fear of the legal challenge, then you have created the very basis of being in breach of the ECT. So is the ECT enhancing this way of a fossil law self-fulfilling property? Thank you.
Thank you, Alessandra, for sketching this case for us to really make it tangible what we were discussing in abstract about the Energy Charter Treaty and pulling it down to a concrete case that is also the most recent and probably the case that at the moment you should be thinking about when you think about the Energy Charter Treaty. And then I want to give the word to Markus Gehring, and we are particularly thankful that he came to join us from the University of Cambridge. I have tried to invite a number of speakers who at least are less outspoken against the Energy Charter Treaty. Can I formulate it like that?
I think that's fair. I find myself in the curious position to probably disagree with both Christina and Alessandra on this panel.
But let me say first, I really tried to let you not be alone. So I invited Stefan Schrill to join us. I invited Pete Eckes to join us, and for different reasons, they did not join us. So I'm particularly thankful that you did join us and that you really came to the lioness den, we can say. And I hope that you defend your position and that we will be able to have an exchange, because I truly believe that also an academic conference must be based on challenging each other's arguments in good faith, and of course based on well-founded arguments. But I'm very thankful that you came to help us challenge our own argument and hopefully refine it as a result.
Absolutely. Thank you so much, Christina. Thank you to the center for inviting me. I'm finding myself in the curious position to sort of more or less defending the Energy Charter Treaty when normally I'm in a room full of economic lawyers where I'm the voice of climate change and sustainable development. Right? I'm the sort of greenie who just got the law wrong for most parts, and now I'm finding myself in a slightly different position. Let me say two things. First of all, political expedience. I think it's wrong to think that investment claims, expropriation claims disappear just because we don't have a treaty, right? There is customary international law. There are other methods that countries like the Belt and Road Initiative use in order to defend their investment claims. Personally, I'd like to have a treaty that is modern, that is respectful of sustainable development, of climate change, rather than having no treaty text, and then having a free-for-all. Second, did the Italian government make all the arguments that we just heard in the Rockhopper case? I severely doubt it. I think arbitration decisions are only as good as the submission to those panels. And I'll give you an example. Let me perhaps pull up my slides. I'm not sure how to do this on the. Fantastic. So I prepared this, I prepared this presentation thinking, is the agreement in principle that we know is out in public, is the possible text that governments are voting on the best we could have? And the answer is clearly no. It's a treaty negotiation. It's not everything the EU member states wanted. It's not even what most EU member states wanted, because it's a compromise. Do we need an investment protection inside the European Union? Clearly not. We all read the Court of Justice, in my view, well-reasoned cases. Some parts of the investment law community called the Luxembourg court sort of made a comparison with Nazi Germany on some of their decisions, and I find that absolutely inappropriate, right? The sort of Gary Bournes of the world should maybe rethink how they bring their cases across. But I find myself also really disagreeing with a large part of the anti-globalization, anti-trade, sort of Occupy Wall Street movement that says, let's just the people decide, right? Let's not forget, Italy has a fascist prime minister. So should we have some international law rules that we perhaps all agree to? I think there is an argument to be made. I'm coming from it from a sustainable development law perspective. Those who are interested, I refer you to Courtney, Seger, and Kalfan, who in 2004 already sort of laid out the general framework. So this is not just an environmental or economic law or human rights perspective. This is trying to get all three perspectives together and speak the same language, because I think environmental lawyers and economic lawyers, for one, discrimination is a dirty word in economic law, whereas, differentiation is all we do in environmental law. So bringing the terminology together can be quite challenging. We all need to transition to a green economy, but the relationship between investment and the green economy is not a black and white relationship, right? It's more shades of gray. Some investment, and that's my main criticism to the criticizers, to the withdrawers from the Energy Charter Treaty, they're neglecting the fact that there are tons of investments that are highly speculative in the renewable energy sector, and those investments are left with very little protection. And on the danger of contradicting myself, inside the European Union, I think we have robust mechanisms that the domestic legal system can deal with it, also because the European legal order sort of sits around it and helps the domestic legal order to cope with really difficult issues such as expropriation. But renewable energy projects don't just happen in the EU, they happen in all energy charter countries. And it's slightly curious to me that a country like Spain, that has lost so many solar cases for what I would argue was a bad policy and legal decision from a climate change perspective, were the first ones to sort of jump onto the withdrawal bandwagon. It's not just about fossil fuel investments, even though they make the headlines. It's also about smaller investments. And these are not just abstract cases. I was involved in the Vattenfall, in the first Vattenfall case. Right, Swedish state company takes Germany to arbitration for denying a permit for a coal-fired power plant. The word climate change does not appear, not for lack of trying, might I say. I was part of the legal team for the city of Hamburg. We tried really hard to get the federal government to argue climate change, because that was the main reason for not granting the water permit. Did the federal government pick up the climate change point? Not at all, right? And we asked and we pleaded. The city-state had no into the legal arguments that were made, and eventually the case was settled for an eye-watering amount. Why did Germany not want to make this case? Why did Germany want to settle its first bilateral arbitration case? Well, because Germany was really afraid, not for the sort of arguments made in the in this particular case, but in all other cases where maybe a developing country government would plead climate change against a German investment, and then where would we be, right? So I'm getting really furious that we're blaming an international regime for something that is really in the hands of governments. And governments don't behave rationally when it comes to the climate issue, in my view. I've often told the story, and there are the Spanish solar decisions, the Czech solar decisions, the Moldovan solar decisions, etc. Right? These are all examples of investments that were not in fossil fuel, and they're still protected under the Energy Charter Treaty. I often tell the story why I'm so pro-investment law, and that's because domestic judges have a really hard time when their own government is in the dock, right? And I've seen this in practice. I was clerking with the Federal Administrative Court in Germany. There was a 200 million euro claim in the early 2000s, right? 400 million German marks. And the very old sort of near retirement judge that I was clerking with had sleepless nights because he was dreaming of all the things he could do, or his government, the federal government of Germany, could do with 200 million euros. Nonetheless, he sided with the investor that was being expropriated by the federal government of Germany, and he made the award. But I'm not so sure that all EU judges everywhere up and down this beautiful continent would come to the same conclusion. Try to be a foreign company litigating against the state that you're investing in, and tell me how you fare. And then tell me again that you don't want any investment protection because we're such developed democracies and we don't need this stuff. Only developing countries need this. That's another dimension that I really find unappetizing, right? We're really okay in the Netherlands to have 140 bilateral investment agreements with all parts of the world. But when we are sort of having our policies reviewed, we're against it. I find that sort of borderline neocolonial. Anyway, I'm saying too much. My publisher always says, mention the book. I mention the book because if the Energy Charter Treaty wanted what to do in order to be respectful to sustainable development, we published the book in 2010, right? It's not like this research is not out there. Also, my employer owns a publisher, and because of that, I always say, mention the other book on transparency by Cambridge University Press. What the Energy Charter Treaty could do is summarized in the 2010 publication. There could be a proper assessment at the EU level of the changes that are being proposed. There could be much more transparency in the treaty making. Why do we only have the agreement in principle? Why not publish the text? Right? A trade diplomat from Brussels, from DG Trade told me, well, they're taking a leave out of the Danish government publishing the Copenhagen Accord. Right? They published the Copenhagen Accord in 2009 on the first day of the climate negotiations, and the accord was dead in the water, right? Because suddenly, all hoo-ha broke loose. I personally think investment decisions are so important that we need to be much more transparent about them. And of course, we need to reform the dispute settlement mechanism. Should we have an investment court system in the Energy Charter Treaty? I think that would make a lot of sense, but I can also see why some of the non-EU countries are slightly more skeptical about it. We need better substantive provisions. And again, the reform of the Energy Charter Treaty goes some way towards that, not just recognizing climate change in the preamble, but really sort of highlighting the non-fossil fuel investments, not granting protection to certain forms of fossil fuel investments, or only for a limited time, and then a successive phase out from the protection for those investments. I think, in my view, generally, that's the right way to go. Maybe it could have been much more ambitious. Should we silo sustainable development in a separate chapter and have an expert process? I'm not so sure. I think it needs to be part of the main part of the agreement, especially climate change. And I wanted to highlight some of the innovations that we've seen over the recent years, right? They're mainly in FTAs. So some of you will be familiar with those. They're very strong, high level of protection provisions, right to regulate provisions in these treaties. And I hear that the new provision on the right to regulate is actually quite advanced in comparison to some of the other investment language that exists. They often also contain non-regression provisions, first tested in NAFTA, but now part of the sort of normal canon of modern free trade or investment agreements. Some agreements go beyond that. We've done 2 studies, one on energy provisions in FTAs in 2013, and then we came up with sort of post-Brexit climate change and energy provisions prior to Brexit, sort of analyzing what could be in that agreement, and we were pretty blown away. I will not mention the other modern agreements. I just wanted to sort of highlight the TCA as perhaps a good example. The TCA, the Trade and Cooperation Agreement, the trade agreement between the UK and the EU does not contain much in terms of substantive investment protection, but in many ways, when it comes to an economic agreement, it's the high watermark with regards to climate change provisions. It declares the fight against climate change as one of the bases of cooperation, contains material breach provisions, is one of the strongest language by calling climate change an existential threat to humanity in the treaty text. It also defines the level of climate protection, which I think is a really good way, not just the carbon neutrality objectives by 2050, but also the 2030 targets, which in the TCA are slightly less ambitious than what was announced under the NDC, under the Paris Agreement, but nonetheless contains a really high level of climate ambition between the two partners, and some of the sort of bonfire of EU law that's planned in the UK will run foul of these level of environmental protection, level of climate protection provisions in the TCA. What I wanted to highlight, this now seems to be a theme in EU trade law, to make climate change a material breach provision. Now, those of you who work on climate change will know that materially defeating the object and purpose of the Paris Agreement is almost impossible, right? You basically have to, I don't know, burn up all your forests in order to get to that particular point. But nonetheless, it sets, I think, an important signal for what the trading relationship between the EU and New Zealand would look like in terms of climate change. And it sets the tone for all implementation of these trade obligations. Again, doesn't contain any investment provisions, also because of the competences of the member states in that particular field. And this is all contained in the recent TSD strengthened enforcement policy decision by the EU in June. The Paris Agreement and ILO fundamental labor principles will become successively part of the normal trade dispute settlement under EU trade agreements going forward. So what does that mean for the Energy Charter Treaty? I really enjoyed the Climate Change Energy Transition Jurisprudence study by Climate Council, a former director of the Stockholm Chamber of Commerce, so she really knows what these claims, what the arbitration looks like. And, you know, again, while there is a connection with climate change, none of the 64 reviewed awards discussed climate change in substance. Is that really the fault of the Energy Charter Treaty, of the arbitrators? Or is that perhaps also the fault of the governments that are very reluctant to make arguments that could be easily used against them? Right? Some governments, Canada, for example, is less worried about that, but other governments are really guarding what they put into any of these investment responses for reasons that they don't want their own investors in other countries to face the same arguments. And yeah, just of the cases that we did a review, there are quite a few coal phase outs cases which now have stopped, but there are also quite a few renewable energy investments that are on the list of the Energy Charter Treaty. I won't go into details for lack of time. An example of how the Energy Charter could perhaps have dealt with the Paris Agreement is the CAI. No, it's highly controversial and will never see the day of light, but it's one of the few agreements that actually says effectively implement the Paris agreements, including the commitments regarding the NDCs, right? These unilateral declarations to the climate regimes, giving them legal weight in an investment treaty, I think would be a really good way, because we know where countries want to go with regards to NDCs, with regards to the energy transition. So why not hold partner countries to account for those actions? Well, we will talk about the Energy Charter reform. I just wanted to highlight that, you know, part of the reform movement actually incorporates very strong sustainable development and climate change language, in my view. I think it's a significant achievement by the Commission to have gotten most of the EU language into the treaty text. It's just bad that some of the member states wanted so much more from that entire treaty regime, and it has a really bad reputation in many environmental circles, as we just heard. What is my conclusion? I think a transition to the green economy with benefits against in the fight against poverty is generally manageable without raising trade or investment concerns, just like environmental objectives could be achieved in other areas. While some investment rules could pose limits on climate policies if carefully crafted, they either don't give rise to investment concerns or can be defended on the basis of their public policy objective. Room for improvement of the ECT, even the reformed ECT, still exists, right? Trying not to silo the sustainable development chapter, maybe defining a level of climate protection, maybe giving more legal weight to the NDCs, and more transparency would be warranted. In my view, regulatory chill is largely a matter of perception and sometimes used by politicians when elements to reduce investment concerns are considered. You're not allowed to expropriate under virtually all EU member state constitutions, right? So it would be quite interesting to see how an Italian court would have dealt with the Rockhopper decision, because what the Italian government and the legislator did was really quite flip-floppy in many ways, and probably also raised some concerns under Italian law for that matter. And then forgive the academic to conclude with further research on the interaction between the domestic climate measures and investment rules is advised. Thank you, Christina. Sorry to ramble on a bit.
No, not at all, not at all. Many thanks for presenting your view here, and I think we should start with perspective. And I sense already there's enough, I have enough questions, but also there's enough of tensions in the panel already. But we will also open up the question and answers after we have given the floor to Natasha Georgiou, who is a visiting fellow at the EY at present. Yes, do you have also slides? So you want to move there? Sorry. Maybe you just take the seat for the moment.
Yeah.
So please go ahead, and you will take us really into the modernized, as it's called by the negotiators, or reformed treaty text of the ECT, I expect, right? That's what you give us a view on in light of sustainability and all this. Thank you. Seamlessly following on from the claim that the new charter treaty offers an improvement.
Thank you. So yeah, by way of introduction, my name is Natasha Georgiou. Thank you for having me. I'm looking forward to a fruitful discussion. I did spend some time at the Energy Charter as an intern and a research fellow and consultant thereafter. So this is obviously a very interesting topic and something that I've been following quite closely. The title of my presentation is Modernized ECT, reflecting EU values and objectives, a multilateral framework promoting energy investment in a sustainable way. So the purpose of my discussion is just to provide some background on the ECT inception. We'll then look at the modernization and why there's a need for reform. The challenge with modernization, basically striking a balance between clean green energy whilst maintaining the investment protection provisions in place. Whether the modernized ECT is fit for purpose, does it reflect climate change and clean energy transition goals and contribute towards achieving the objectives of the Paris Agreement? And then we'll then look at the modernized ECT, whether it reflects core EU values, i.e. does it promote investment in a sustainable way? And finally, EU withdrawal from the ECT, is it an alternative to reform? And if so, can the EU deviate from multilateralism and a rule-based legal international order as a fundamental value and principle of EU external action? So just a bit of background with respect to the inception of the ECT. It was initially introduced as a means of strengthening the rule of law, creating a level playing field, and establishing intergovernmental cooperation in the post-Soviet state, post-Soviet space. It was meant to establish a set of rules to mitigate the risks that were associated with investment in the energy sector. The dissolution of the Soviet Union also presented these opportunities for further energy-related investment and further economic cooperation within Europe. And ultimately, what was very much perceived was the fact that this platform, this political and economic platform, was best dealt with a multilateral legal framework, which would be the most appropriate architecture for international cooperation in the energy space. But since then, there have been tectonic shifts in the energy landscape. The energy landscape has been changing quite tremendously. And obviously, the ECT has been proceeding within this new context where there is a need for energy investment to improve climate action and promote clean energy towards a low carbon economy. And ultimately, the question that has been surfacing on several occasions is whether a framework that was established in the 1990s in Eurasia is still relevant today. Can it go beyond the chartered origins during the Cold War to address the modern day challenges of climate change? So there is a need for reform. The ECT has come under a tremendous amount of scrutiny, mostly two reasons. Predominantly, it's considered to be protecting the fossil fuel energy, oil and gas, and undercutting sovereignty. And it's therefore considered to be incongruous with the Paris Agreement, because it allows fossil fuel companies recourse over countries regarding their climate policies rather than bolstering climate change. And basically, by protecting all the investments, including fossil fuels, it does affect a state's ability to tackle those climate change policies. So any state action that affects a company's profits from these investments can be challenged in international tribunals, and governments will effectively then be liable to pay compensation. So the EU, as a key stakeholder, has been actively engaged in this modernization process and has been keen to reform the ISDS and the investment protection provisions in place to include new provisions on sustainable development and climate change. And the Commission has articulated on several occasions that whilst it is committed to modernization, it's important and imperative that the core EU objectives are achieved, and failure to do so, it will withdraw from the Energy Charter Treaty. And the core EU objectives are alignment with the Paris Agreement and the Green Deal. So obviously, there's a massive challenge with reform. It's basically striking a balance between a treaty that facilitates clean green energy whilst not undercutting the investment protection provisions in place that are needed for further investment, including investment for green energy investments. And the EU expressed its view that it wants the whole objective with reform and a modernized ECT is to facilitate investment in the energy sector in a more sustainable way. And one of the ways in which they proposed doing that was amending the ECT's definition provisions, in particular Article 1.5, whereby economic activity in the energy sector would be amended. This was largely seen to be specifically focused on fossil fuel related investments, not taking into consideration new trends in renewable energy. So they proposed amending it that way to deal with these, providing a more sustainable energy investment environment moving forward. So yeah, modernization was expected to achieve several objectives. These include providing legal certainty, clarifying the role of intra-EU ISDS, introducing greater transparency, and ensuring the ECT reflects climate change, clean energy transition goals, and contributing towards the objectives of the Paris Agreement. And obviously, recent claims brought against the Netherlands following the decisions to phase out coal-fired electricity this has obviously been front and center. It's raised alarm bells. So obviously the stakes are high. Failure to reform the Energy Charter Treaty does bring the future of this treaty into question. And for this reason, you know, it has been a hot topic, as Christina mentioned earlier. So we've got the agreements in principle. An agreement was reached in June. It's still subject to final agreement. The text was published in September this year, and the agreement in principle will be formally adopted in November. And with respect to the modernized ECT, it does not exclude fossil fuels from its investment protection. It hasn't removed that from its scope. Instead, what it provides is a flexibility mechanism whereby contracting parties, the states, can decide to exclude or carve out fossil fuel protection, depending on their energy and climate goals. So in that respect, if we ask ourselves, is the modernized ECT fit for purpose? It does appear to provide indefinite protection for the fossil fuel investments, which is incongruous with climate goals. And even if we take into consideration the EU and the UK's very ambitious 10-year timeframe, this is still inconsistent with the science, because according to the International Energy Agency's roadmap for net zero by 2050, there's no place for fossil fuels beyond 2035. So subsequently, there's been this call for withdrawal. You've seen countries leaving. We've had Spain, Poland, and recently the Netherlands. But even with withdrawal or departure from the Energy Charter Treaty, you've got, pursuant to Article 47, the sunset survival clause is still in place. It remains unchanged, which means that the very deeply entrenched investment protection provisions and arbitration is locked in for 20 years. And this is incompatible with the urgency for net zero energy transition. But the counter argument to that would be that continued protection for fossil fuel investments under the ECT does not equal continued support. That should not be construed as continued support. Investment protection is not absolute. It merely guarantees that there is fair and equitable treatment and compensation. It prohibits expropriation without compensation. So in light of that, a state's right to regulate and its climate change obligations should not be tainted by these guarantees that have been put in place. It should not be a barrier to rapid climate action by these contracting parties. So in that respect, we can say that the modernized ECT is not a panacea. It does depend on how arbitral tribunals engage with the new text and the interplay of the obligations under the Energy Charter Treaty and the Paris Agreement. So it still remains to be seen how investment disputes will develop under those new rules. So reflecting on that, does the modernized ECT reflect EU objectives? Does it promote energy investment in a sustainable way? And arguably, we could say it doesn't, because it doesn't give rise to the mounting global challenges regarding energy investment, climate change, and sustainable development. We could also say that the reform neglects the urgency of the sustainable development goals, such as goal number 13, relating to climate action, and also the Paris Agreement goals and commitments. And effectively, we could say that in order to achieve the climate change mitigation and adaptation goals under the Paris Agreement, the ECT would have to enable and expedite the transition from high emission investment towards low emission investment. So failing to advance those climate goals can effectively hinder states' climate action, and therefore the ECT reform makes the very urgent need for climate policy very difficult and costly for governments to implement. So, as mentioned, we've got the agreements in principle. It will be adopted in November. We have to ask ourselves whether the ECT is capable of a new lease of life, moving from the ashes of the Cold War, from an investment treaty that facilitated protection towards fossil fuels. Can we move from that to a more green treaty, which fosters green investment, sustainable development and climate change. And that's obviously something that remains to be seen, which is evident by the recent withdrawals on the grounds that it's not sufficiently aligned with the Paris Agreement. But reflecting on that, can the EU withdraw from the only multilateral treaty in the energy sector, from a framework that promotes the rule of law, from an architecture for global energy governance, and an instrument that was largely perceived to be a tool for its energy acquis and norm export in Eurasia back in the 90s? Can the EU withdraw from the Energy Charter Treaty if that is what it symbolizes and what it stands for? And if so, how does that align with the EU's values and objectives in its external action? So if we look at Article 2, which relates to the EU's values, it includes the rule of law. If we look at Article 3.5, which is the promotion of values in the EU's external action, we know that it says that there should be a strict observance and development of international law. And then further, if we look at Article 21, which is the general principles and goals for EU external action, it speaks about seeking to advance the rule of law, promoting stronger multilateral cooperation and good global governance, promoting multilateral solutions to common problems. So from that, we can see there is a very strong link between a rule-based international order and multilateralism. And the Lisbon Treaty brings that to the fore in the EU's external energy policy. And the question remains to be seen whether the EU can indeed deviate from that multilateralism. Can it withdraw from the only multilateral energy treaty, which would effectively be undermining multilateralism? So we know from Article 3.5 and Article 21, it illustrates the dual purpose of the EU's commitment towards international law and multilateralism, not only as a value of the EU, as a value unto itself, but also for the purpose of developing a rule-based international order, which the EU then uses in turn to promote its own fundamental values, which includes the rule of law. So in that respect, can the EU withdraw? Also, wouldn't withdrawal then be incongruous with the initial objectives of the EU, which was creating a multilateral legal order, promoting the EU values, promoting universal principles such as non-discrimination, transparency, trade liberalization, a level playing field? So the question remains, can the EU withdraw, and would withdrawal not be then construed as deviating from the universal principle of the rule of law? Would it only be perceived with respect to a policy consideration? So in that respect, withdrawing from the ECT does raise several questions. There are some challenging things that need to be considered. Also with respect to the discourse about the ECT, can we say that it's purely aligned to values and objectives? Because if we consider that a lot of the criticism has been related to many cases that have been brought against EU member states, it's important to consider that also several of those cases relate to renewable energy protection. We just need to remind ourselves of the plethora of cases that were brought in Spain. So yeah, there is a question about the EU's discourse and whether it's purely related to values and objectives. Furthermore, it's important to recall Russia's withdrawal from the Energy Charter Treaty after the whole sort of Eckes affair. If the EU withdraws, would they be adopting a similar approach, and would they not be inadvertently endorsing Russia's actions against Eckes and undermining the significance of the Eckes case and upholding the rule of law? So, and another thing, EU withdrawal, it would further fragment the legal architecture, moving from a multilateral framework to bilateral and unilateral regimes. And this would be a departure from the EU's usual normative approach and agenda, which is promoting values through regional integration and multilateralism. So just to conclude, if we look at the core EU objectives now, which is consistency with the Paris Agreement and the objectives of the Green Deal, and how these align with the EU's aims in its energy policy under Article 194, which is promoting energy efficiency and the development of renewable energy, we can arguably say that The modernized ECT and ECT reform does not live up to those EU core objectives. However, if we look at the objectives of when the ECT first came into being, which was promoting the rule of law, multilateral framework, a level playing field, energy governance, energy cooperation, and investment in a post-Soviet space, yes, it does fulfill those objectives, and those objectives do align with the EU's values, which are promoting the rule of law, promoting stronger multilateral cooperation, global governance, and creating a multilateral solution to common problems. So in that respect, can the EU withdraw? Is it an alternative to reform? And if so, would it be considered a compromise on EU values, given that it's not aligned with the values that the EU strongly advocates in its external relations? And just reflecting on that, whilst there is a need for the legal regime to be adapted to the new realities and urgency of climate action, the challenge is the reinforcing investment towards green energy, clean, renewable green energy, whilst not undercutting those investment protection provisions in place. And a policy-orientated approach will generate additional challenges for energy multilateralism, as withdrawal would put further the much needed further energy investment in renewable energy. It will put that at risk and it will diminish those climate change efforts. So despite criticism of the ECT, EU withdrawal would entail wider political risks, and therefore we need to take, I think, or this is my opinion, I think a more long-term view of multilateralism needs to be taken, not only as a value fundamental to the EU, but also as a value that it very much advocates in its external relations. Thank you.
Many thanks.